Can people hear me fine? Okay. Hello, everybody. I know now's about the time that your lunch is setting in, so I'll try to keep you awake as well as I can. I'm here to talk about the question of no law or soft law or hard law, and I will start by offering a quiz. Does anyone happen to know this location? I'll give you a clue. It's in Wilmington, Delaware. It's 1209 north. It is not. This is 1209 North Orange Street in Wilmington, Delaware. It's probably the fourth most powerful address in the United States. This is the home address of about 200,000 American companies, including Walmart, Coca-Cola, General Motors. Now, this is an example of how anomalous U.S. law is when it comes to corporate governance. We let our corporate law be given by states. And so what effect does that have? It means that states compete against one another, right, to provide corporate governance. And how do they do that? Do they compete on the basis of which one is going to provide the most rigorous oversight of management, or the strongest protection for stakeholders? Of course not. Right? This is the way it works in the United States is for there to be the traditional race to the bottom. And regardless of now, some people have said through the years that this is actually a race to the top. But of course, I think the best argument are even with regard to shareholders, is that it's a race to the bottom, and certainly it's a race to the bottom with regard to any stakeholder other than shareholders. One can be agnostic about shareholder protection, but one cannot be agnostic with regard to stakeholder protection. So, what is the effect of this practice in corporate governance law in the United States? One of the effects is that Delaware gets to export its law to the rest of the United States and indeed the rest of the world. You can be headquartered in Los Angeles, have your largest factory in Bangalore, and have your shareholders living in Munster, but the law of your internal affairs of your company is going to be dictated by Delaware corporate governance. So what this in effect does over time is create soft law. Soft law in two ways, right? One way is that it ratchets down protection because states are competing among one another, against one another, to attract incorporations by attracting management, and that the management will choose locations and jurisdictions where they will be most protected, where their obligations are lowest, and also. This goes back to something Bernali was saying earlier today. It makes the law softer in that it creates law that is less precise, that's more vague, more general, articulated at a higher level of generality. Now, this softness of law, both in terms of low level of obligation and also vagueness of law, could be a good thing in certain situations, right? One could imagine that this freedom that's offered to directors might be used by directors to liberate them to do the right thing, right? To take into account the long-term interests of the firm, to take into account the stakeholders who are investing in the firm in various ways, whether they be communities or consumers or employees or shareholders. And to have that freedom from legal obligation empower them to do the right thing without fear of strike suits or legal oversight. One could also think that the vagueness of legal rules might be a good thing because in a similar way, right? It empowers the judges to be very contextual and in their rulings, right? One downside with precision in the articulation of legal rules is that it both defines in and defines out, right? One could say that and we are all, many of us here, most of us here perhaps are lawyers, and if you're faced with a precise rule, and you're asked, well, how do I avoid that rule? It's much easier to avoid the rule if the rule is precise. On the other hand, if the rule is articulated at a high level of generality, act with due care, act carefully, act consistent with your fiduciary duty. It's harder to avoid that obligation ex ante in a very precise way, and so when a judge looks at behavior to adjudicate it ex post, the generality of the rule might allow an honest, careful, sophisticated judge to take all kinds of context into account in making her ruling. So one might say that in some areas, vague general rules or obligations couched and articulated at a high level of generality might be a good thing. So one might imagine a situation in which soft law, both in terms of level of obligation and vagueness, might be beneficial. And in fact, this is the conventional wisdom in the United States when it comes to corporate governance law. The business judgment rule is necessary to empower corporate managers to use their expertise to act in the long-term interests of the firm. Moreover, judges, especially in Delaware, the reason why we go to Delaware is because judges are experts. The judges here are experts, and we know when to defer and when not to defer. Now notice that there's some tension between these two in the conventional wisdom, right? Like, why would you need expert judges when what judges are supposed to do is to defer, right? You would only need expertise if you think that judges should intervene. But in any event, that is the conventional wisdom, right? That the low level of obligation plus vagueness and highly general rules empower both business managers and judges to act in the best interests of the firm over time. Now, I'm here to tell you that neither of these beneficial effects accurately describe what is happening in the United States. In fact, if it is not that at all. The softness of the law, both in terms of its level of obligation and in terms of its generality of articulation, have been used to the detriment, in my view, of the stakeholders of the corporations, including the shareholders over time, and to the detriment of how we regulate corporations in America. So let me talk some about both of these components, the level of obligation and also the high level of generality and the vagueness with which they are articulated in the United States. In terms of the duty, so the low level, at this point in America, the level of obligation as a matter of Delaware corporate governance law is quite low. The duty of care is essentially non-existent. The duty of care can be opted out at the level of the company in corporate charters, and even when it is not opted out, it is enforced only really, really rarely. In fact, it's probably not correct to say that it's a real obligation at all. The duty of loyalty, right, to the extent that we have any duty at all, the courts say, well, the duty of care is not that, it's very, we'll consider very deferential. We'll apply the business judgment rule. The duty of loyalty, however, we will be much more careful about and much stricter about. But even there, the duty of loyalty has over time become essentially a market-based test. Right? Are you doing, it is not what we have always been taught, or what I teach my students, that it once was, right? The punctilio of an honor the most sensitive, right? It is not what we think of as a fiduciary owing duties of trust and and loyalty to a client. It is, don't do any worse than what you would get in the marketplace. That doesn't sound to me like a duty of loyalty at all. And so and with regard to stakeholders, right? There is no under Delaware law, there is no enforceable duty. Full stop. One can take into account the interests of stakeholders if you choose to, as long as you say that it's in the long-term interest of the shareholders, and insofar as it doesn't conflict with the interests of the stakeholders, for example, in a takeover situation. But there's no enforceable duty towards stakeholders at all in Delaware law. Now, there for a while, there was a notion for a decade or so that maybe the Delaware courts were building something along the line of a duty of good faith. Right? There was some talk about that in some earlier cases, the Disney case, for example. But after a decade or so, what the court decided in a case called Lyondell was that the duty of the duty of good faith was really a part of the duty of loyalty, and that the standard by which that the court would apply is a standard of utter failure. So as long as you didn't utterly fail to engage in good faith, then you've satisfied that duty. Now, there is no other area of law in which one could imagine that the duty to act in good faith is to do something other than utterly fail, right? Like, that is not your duty of good faith in any other. If you have a duty of good faith to your children, right? Let's hope that our duty is other than not utterly fail. So what does that mean? That in reality, if we put our legal realist hats on, pardon me, the real rule of law in Delaware is that managers win, and that the market is the primary constraint on managerial behavior. So that's with regard to the level of constraint. Now let's look at it, the same question of soft law from the standpoint of judges. Now, thank you. Where do we stand with regard to the softness of law with regard to judges? Now here, my assertion is that the vagueness of legal rules essentially is a cloak for judicial arbitrariness, and again for judicial protection of managerial prerogative. So here I draw on notions of what law, again, go back to what law is. Law is constraint. If law is anything, it is constraining. And where there is no constraint, there is no law. And I think when it comes to how we think about judicial opinions and the like, there are three different problems with how the generality of law. There's a problem of result fixation. There's a problem of vagueness, and there's a problem of obtuseness. Right? If judicial opinions are too obviously focused on result and thinly reasoned, then they're illegitimate. If the rules that they articulate are vague, and so vague that they are easily transformable depending on the outcome that is desired, then they are illegitimate. Sometimes judicial pronouncements are illegitimate for a third reason, which is that they are obtuse. They are distant from what people consider to be a real any real connection to the world around us. And I think in Delaware, pardon me, judicial decisions are subject to all three critiques. They are result-oriented, they are vague, and they are obtuse in various situations. For example, let me talk just to go back to the case that I mentioned before, the Lyondell case, which was it was a takeover case. The facts don't really matter for us right now, but in that one case, the court had articulated three different ways to describe the duty of good faith. They said reckless disregard, utter failure, and that's just note, they both sound pretty low, right? But they're also different. One is about a mental state, one is about behavior. And then in a third part of the opinion, they said you had to, a plaintiff would have to satisfy both. My point is that even in their own opinions, they are within one opinion, they have three different answers for what the obligation is for management. And if that's true, then what is really happening is probably that the court is giving them itself enough leeway to have a correct answer or a different answer in the next case. And if that's true, then a cynic might say that this is purposeful, right? That this is trompe-l'oeil. Now, this is an architectural term. Do you know what this? Do you know this word? I didn't. Trompe-l'oeil is where you have like a wooden pillar, but you paint it to make it look like marble. It's used a lot in southern United States homes that where they want it to look very stately and ornate and structurally stable, but in fact it's just made of wood, right? So in a way, this is trompe-l'oeil as a matter of judicial pronouncement. It looks like it's marble, right? It looks like it's very structurally sound and strong, but in fact it's really much less strong and much less stable. So if all this is to say that is by way of warning for those jurisdictions, if you want to move away from voluntary codes of compliance and move toward judicial enforcement of legal rules, one has to be very careful that you don't fall into this trap. It also begs the following question, right? Which is, if one wanted to do something different, how would one do it? If one wanted to stay within a judicial enforcement regime, but wanted to have harder law, what are one's options? Now let me, and here's where I'm eager to hear your views on this, but here's a few ideas. Now one might say that one could say that a board or a management structure should have a firm, enforceable obligation to take into account all stakeholders, at least the three main components, right? Those that contribute money or assets, those who work for the company, and those who buy from the company, right? Those are the three things that any company has to have. You've got to take into account all three of those to do your job as a manager. Right? You have to sustain this over time, and for a company to sustain over time, you must take into account all three. So one might say that it should be an enforceable obligation and judicially enforceable that a competent managerial leadership of a company must take into account all three components of this in order to satisfy their obligations. Another way to say this is that it is inconsistent with fiduciary duty to maintain one supreme stakeholder within the law. And if it looks like over time that a board is prioritizing one over the others over time, then that's a violation of fiduciary duty. One could say that there should be an obligation of consideration and consultation, right, to take into account all of these components. Moreover, one could say that the obligation of a manager should be to look at the long term, toward the horizon. And if there are examples or instances in which a manager or a board fails to take the long term, that should be and could be judicially correctable. One could also say that there is a structural safe harbor. One could construct a framework of fiduciary duties that would say your obligation is to take into account all these stakeholders. And there's a structural safe harbor that if your board looks like it takes into account these components, we will pardon me, be more deferential to you than we otherwise would. So here's where I come down on all of this. That as presently constructed in the U.S., that our law is so soft that it is no law at all, but that does not have to be the way we do it. And we could still do it within a judicial framework, but there has to be real law and real obligations and within that judicial framework. And judges have to be willing to step in and assert their prerogative and their oversight. I'll stop there and eager to hear your questions.
Thanks, Ken. Very interesting. I'm sorry I kept putting the post that I had to, but I could have listened to you go on for a lot longer. I'm sure we'll have a chance when you have a chance to answer some questions. Can I take any questions from you?
Sure, one question, very short.
Okay.
Yeah. So, who do you think has the power to reverse the race to the bottom? The institutional investors, the pension funds, or the state legislature, or the thinkers like you?
I apologize for coughing so much. I got sick the day before I came, and I rushed to the doctor and got some antibiotics. So I've been on antibiotics the last couple of days, but I'm not contagious anymore. I'm told. Yeah, we hope not contagious that way, Jean. So here, in reality, in the United States, this is a big problem, right? Because every time somebody like me says we need harder law, everybody says, oh, you know, Delaware is never going to do it. So there are two answers. One is you've got to have national corporate governance law, like every other major jurisdiction in the world, or other states within the United States could start asserting their own rights to govern companies headquartered in their state. And I think that's consistent with a number of ways that we have our laws elsewhere. But it's bizarre, isn't it? For companies can't choose which environmental law applies to them, right? Companies can't choose which labor law applies to them. They shouldn't be able to choose simply by filing a piece of paper and filing it in the filing cabinet at 1209 North Orange Street, Wilmington, which corporate law should apply to them.
All right, thank you. I could just say what Andrew said. It's just wonderful always to listen to you, Kent. So many interesting and deep things to think about after all the presentations that I've attended that you've had over the years. I think that I heard you saying that there are instances where soft law has been used to the detriment of stakeholders and shareholders. So I just wonder whether you can expand a little bit on that. I just couldn't get the point exactly.
Right. So there's certainly situations in which, because the law is so has such low level of obligation, that things like executive pay, that it is so outstripped in any real sense of proportion in the United States. Now that's an area where there's no real mechanism for shareholders to complain. If they filed suit, they would lose, right? But it's even clearer with regard to other stakeholders.
Again, very deep presentation, and I think a lot of very interesting strands to explore. But I have just two questions. One is about your emphasis on the substance of the law to evaluate whether it's soft or not, and that goes back to the resistance that I had with Bernali's presentation. I think you're focusing correctly on the substance of a law to evaluate whether it's hard or soft, but that's precisely why the use of the word soft is confusing, because while you're correct, that presupposes the precondition for something to be law, which is source and authority, right? So in the Delaware case, it's properly promulgated, it's by a properly constituted legislature, blah, blah, blah. So it satisfies the preconditions for something to be law, whether the content of the law happens to be soft or not, right? In contrast, a lot of the instruments that Bernali and others use in the soft law sense, in human rights norms, principles, standards, blah, 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 don't meet the precondition in terms of form for something to be law. By definition, they are issued by bodies which are not legislatures. They don't have formal legal authority, so on and so forth. So in the two instances, the softness is referring to different aspects.
That's right.
And the Abbott and Snidel definition, which again I've parsed very extensively, really presupposes the precondition, which is that it's properly issued by a legislature or some body which has formal legal authority. So then related to that is your second critique about the Delaware courts' decisions being illegitimate. You might be correct in that they're very outcome-oriented, consequentialist, and therefore illegitimate. But you're using illegitimate there in again, a normative sense, because it's not illegitimate in a pure formal legal sense, right? In the sense that a Delaware court's judgment has legitimacy from a formal legal authority sense, because it's a court of proper judicature, blah, blah, blah. Whereas a court which is referencing a norm, which is known law, even if it's couched as soft law, would be illegitimate to the extent that that reference is to something which is not real law. So that distinction is crucial, and that's why, to my mind, it's better to use the terms law versus non-law and then evaluate content and substance based on strength of the obligations.
No, I hear that, right, and I think that's a good point. But and speaking more broadly, and I think your comments go to this, the legitimacy of a court decision, I think, is an elastic term, and my paper actually goes into this in more detail. I think that over time, for a court to be legitimate, they have to adhere to the obligation of explanation. And that is the difference between a court and a legislature. Legislature passes an act, a statute. It doesn't have to explain. A court, to be legitimate over time, I think has to explain. In other words, the United States Supreme Court, when it issues an opinion, it issues more than a statement that says it is so ordered. It issues, these are my reasons it is so ordered. And I think for a court to stay legitimate over time, those explanations have to make sense. And my assertion is that over time, the Delaware courts are making less and less sense and becoming less and less legitimate because of that. And as they become less legitimate, it in effect becomes less lawful, or there's less law there. And it's more will than law.
Some egos of the managerial hypothesis might resist that by saying, what you call lack of explanation is actually provided by the latent explanation of deference.
Yes, one could say that, but it's belied by the fact that even within their own opinions, they're inconsistent. Right? So one could say we defer, and we believe that we should defer for all these various reasons, which they have done. But then when it comes to but they never say we will defer always, right? So that. But in effect, they are out of they're so in a way we have the worst of all worlds, which is that is in effect what they do, but they don't say that that's what they do. And if a court says that is continually dishonest about what they are saying they do, then I think over time it ceases to be law and becomes will.
We'd better move on. Jill's got a next question.
Yeah, mine's a short one. I haven't had a chance, unfortunately, to look at case law on director duties in the US. So can you give me a sense? You're asserting that the director duty of good faith and loyalty is fairly emasculated. You know, how many cases have been brought against directors in the last 5 years? And can you give us an example where there has been a successful prosecution and the facts of that case, so we get a sense of what the threshold is?
Well, this Lyondell case was 2009, right? So, and that was the last big pronouncement in Delaware about what the obligations of management are, and that's where they were trying to flesh out. They for a decade before that they've been trying to figure out what good faith meant, and then Lyondell was the case in which they essentially decided we're not going to try to give meaning to this doctrine of good faith. So we're back to where we were with duty of care, which is non-existent. Duty of loyalty is basically a market-based test, and the duty of good faith is not really a component anymore. So there haven't been any big prosecutions where or any big cases in which the management has lost when they say that they're acting in the interest of shareholders, even if they're acting pretty poorly.
Okay. We'd better leave it there because time's gone on. Always wanted to get hold of one of these and tell people about my rendition of Mama, Mama, We're All Crazy Now. That was one of Slade's big ones. Thank you very much, Kent, for a very, very entertaining and very instructive talk and for some very good questions.
Great, thank you.